Hello and welcome back to the business. We're now on to video number 3, which is really pre-legal. This is where we're using a debt recovery company like yourself, Nigel, and we haven't got down the route of going legal yet, but is there anything we can do?
Yes, there is. First of all, you can use the debt recovery company itself to arbitrate against the debt itself. So we can maybe go to the your creditor and say, okay, you can't afford to pay, maybe you can pay on instalments, maybe we can negotiate an instalment plan or certain amounts of payments over a period of time. If that doesn't work and they want to go somewhere completely separate, then there are 3 options that you can have. There's mediation, which handles a third-party qualified individual who will mediate on behalf of both parties. It's not mandatory that you accept their result. However, you can sign legally to say that you will accept whatever they decide at the end of the day. These qualified individuals can be solicitors, insolvency practitioners, debt management companies such as myself. You can go down an arbitration route, which is a slightly different route, and you are mandated to accept what they say. And the arbitration, again, is done by a qualified individual, a qualified arbitrator, who's usually a solicitor, an insolvency practitioner, or myself, who's an accountant, but a qualified arbitrator. Or you can go through something that's rather odd, which people probably haven't come across, which is called neutral evaluation. And effectively what happens is a third-party individual, tends to be an accountant such as myself, will evaluate the debt itself. So we'll see whether or not you should have owed that debt, or whether or not maybe there's a percentage of that debt that can be not recovered. And this, in the case of companies such as building companies, for instance, there's a substantial amount of building companies who have issues with debts who go to arbitration or go to neutral evaluation because someone will always argue the difference between a job that's been done.
If you use any of those though, Nigel, who ends up paying the bill of the solicitor then?
Both of you does.
Right.
So you both pay a portion of that particular bill. Now, the bills are usually fixed and they can be anywhere between £100 and £300.
But we're talking there really about people that are just wanting to pay but are not happy with the way that the bill is, probably. What about people where they're just stringing you along? That wouldn't work for that, would it?
If someone, we have a saying, can't pay or won't pay.
Yeah.
If a person won't pay, that's great for a debt management company because we know they've got funds, they just won't pay. Well, we can take action against them. If they physically can't pay because they don't have the money and that's why they're stringing along, that is difficult. The old saying, you can't get blood out of a stone. If these people don't have the money, it doesn't matter how many threats you make against them, they're not going to be able to pay you. But if it's the ones that won't pay, what can you do? And you decide that you're not going to go through the mediation, then unfortunately you're going to have to go down the legal route.
Yeah. So, pre-legally then, that's all we've got left until we go now onto the legal route. Thanks for listening to video number 3. Let's move on to 4, the legal route.